Good morning. Are you Cody Dent?
Yes, ma'am.
And Mr. Dent is on probation in two cases, 13-17772 and 22.
And right from the start, the judge's tone tells us everything. This isn't a casual chat. This is a felony arraignment, and every yes, more a yes, sir, is locking in the foundation for a legally binding guilty plea. Notice how fast the pace is? That's very normal. Judges don't waste time once they enter the plea-taking mode.
41052 for the offenses of obstruction or retaliation and theft of property. Those both have motion to revoke pending. And then there is a new allegation or new indictment in cause number 250807 of burglary of a building. And Mr. Samuel,
Yes, Your Honor, I've been hired to represent Mr. Dent. I went out and visited with him this past weekend, and I've also spoken with him this morning. And as a result of my evaluation and talking with him, I believe it's merited to have someone appointed to give a professional evaluation. We realize that he is on probation. I realize there is a new charge. This is our first setting.
This moment is subtle but important. When the judge pauses over the restitution amount, she's signaling something judges rarely say out loud: your ability to pay matters. Restitution isn't just a number, it's a test of responsibility. And watch how the judge tries to make it realistic by lowering it. Judges hate setting people up to fail.
I had an opportunity to complete discovery, but I think upon getting the information from discovery, and if we can set for bond hearing at a later date, maybe next week if possible, we believe that the results of that evaluation will show that there's possibly some alternatives that are available.
so it's set for bond hearing today on those motions, but you want some time to get up to speed on that other case. You want me to put that off and just hold it?
Yes.
Okay.
Yes.
All right.
At least until next week. I'd like a quick turnaround because right now there is no bond.
Right.
And he needs to get assistance.
Okay. An evaluation won't happen in a week.
I understand.
Okay. So but you still think give you a week to get up to speed?
Correct.
Bond hearing next week?
Correct.
And then I'll look at your motion for the...
And boom, right there. The judge catches movement. Tiny interruption, but in court, even a fidget can derail the flow. This is why courtroom etiquette matters. One distraction and suddenly the judge has to reset her entire thought process. Ever had a teacher stop mid-sentence to glare at someone tapping a pen? Multiply that by 10.
Evaluation will take care of that.
And I've talked with the prosecutor.
Okay. We'll reset it. How's next week? Are we?
Yes.
We're good. Okay. We'll reset it for 1 week for a bond hearing on those two motions.
Right.
Thank you.
Thank you, Your Honor.
Good morning. Are you Justin Franklin?
Yes, ma'am.
And in cause number 250514, Mr. Franklin's charged with aggravated robbery. Mr. Lewis, what is the announcement?
Well, Judge, I'm Mr. Franklin. I understand that the complainant witness had been in touch with the state on this one.
Judge, may I put a few things on the record, please?
Yes, ma'am, of course.
First, may I have the name Kayla Davis called?
Will you call the name Kayla Davis, please? Good morning, ma'am. Are you Kayla Davis?
Mm-hmm.
Ms. Malfino, do you need some time maybe to visit with her, or do you want to go ahead and put something on the record?
Judge, if you
Okay.
just mind swearing your...
Ms. Davis, would you please raise your right hand? Do you swear or affirm the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am. Thank you. Go ahead.
Ms. Davis, would you please state your full name for the record?
It's Kayla Davis.
Held you all at gunpoint and stole your purse and wallet, right?
He didn't hold us in gunpoint and he didn't steal my purse nor wallet.
Did you tell the police that that's what happened?
No, ma'am.
Okay. So if that's what the offense material reflects, and that's what the grand jury proceeded on with an indictment for aggravated robbery, are you saying under oath to the court today that that did not happen?
Yes.
And you have many times called my office asking that the case be dropped, correct?
Right.
You've come in and signed a non-prosecution affidavit?
Yes, I have.
You have called saying that this did not happen and that you're not going to cooperate with the state, correct?
Yes, I have.
Are you in fear of Mr. Franklin?
I'm not.
Is he pressuring you to do this?
No.
And do you understand that if the state does not proceed with this case, that you're taking matters into your own hands.
Yes, I do.
With respect to your safety.
Yes, I do.
And that's what you want me to do.
Yes, drop the case, please.
And you're asking Judge
I'm
West
asking
to
Judge
allow me
West
to
to-
drop the case.
Drop the case.
All right.
OF. This is one of those courtroom reality check moments. Dress code may feel old school, but judges enforce it hard because it signals respect for the process. When she says time to grow up, that's not just fashion policing, it's the court warning your behavior outside the crime matters just as much as the crime itself.
You can step back.
Thank you.
And Judge, just for the record, if I may, obviously with those facts, obviously the court is aware of experiences you and I have both had in the past. I think there was something more to the incident. She's obviously not going to cooperate with me. She's obviously also his spouse. And so at this time, with the court's permission, I would move to dismiss, but I just wanted to be sure all of that was on the record so that if something were to happen in the future, everybody is aware that those were specifically her wishes.
All right, if that comes through based on all of that, I don't know how you can do anything else, and so I'll sign that. Mr. Franklin, I'm not sure what, if anything, happened. My thought is something did happen. Hang on, just let me talk, okay? Don't talk yourself out of this, because here's what can happen. It's not easy, but it is possible to go forward with cases without the complaining witness. So whatever happened needs to not happen again. You need to get a grip on whatever anger, whatever issues you have. If you've got someone here that cares about you and you want to be a part of their life, that's not what you do to people that you love.
Yes, ma'am.
And it's definitely not what you do where there are children involved.
Yes, ma'am.
Do you understand?
Yes, ma'am.
All right, go back with the bailiff. Good morning. Are you Tracy Haynes? And this is cause number 240514. I'm going to take judicial notice of the court's file. Mr. Haynes was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration.
Watch this pivot, it's almost cinematic. 1 second she's guiding one defendant with compassion, the next she's all business. Courtrooms run like conveyor belts of human stories, and judges switch gears instantly. This is where timing becomes everything. If someone doesn't show up, even by minutes, it can cost them thousands in bond forfeiture.
And I received a packet from them dated June 23rd of 2025 with that report from Dr. Samantha Guzman with the opinion that Mr. Haynes has achieved competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No, Judge.
Then at this time, I will find Mr. Haynes is competent to stand trial. And will he waive the formal reading of the indictment, Mr. Parker?
will.
All right, Mr. Haynes, in cause number 240514, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of obstruction or retaliation from February 3rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
The stuff on the computer.
The stuff on that computer tablet, did you go over that before you signed it with Mr. Parker?
Yes.
And do you understand those documents that you signed? Speak up, please.
Yes, ma'am.
And do you understand if I follow the agreement that
Right out of the gate, Cody Dent in Deep 2 probation cases a new burglary charge and motions to revoke hanging over him. This isn't just a bond, hearing it's a high-stakes balancing act between second chances and legal consequences. Will the court bite, or is this his last shot?
you've made with the district attorney that you'll be waiving or giving up any right to appeal? So if I follow your agreement, you can't change your mind later. Do you understand? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. Speak up, please. When you're answering, I need you to speak up. And sentence you in accordance with your agreement to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Good morning, sir. Are you Jack Hooper?
Yes, Your Honor.
And in cause number 17-27896, Mr. Hooper is on probation for driving while intoxicated, third or more. There was a motion to revoke filed. We were previously here. Entered pleas of true to counts 1 through 6. I've received an updated pre-sentence report, and the agreement was for a cap of 4 years. Is that correct?
That's correct, Judge. He's indicated to the probation officer, indicated to me that he would rather not be put back on probation. He's asking to be sentenced to 3 years. He doesn't have, he doesn't have any new cases as violations or the possession, testing positive. He seemed to report to the probation department and did everything he did. The problem was he had an issue with marijuana. We're asking that, I think he should be given some consideration for that. We're asking for a 3-year sentence.
So you stopped reporting back May 5th of 2021. So didn't really report as
I apologize.
directed.
I spoke that.
You've been an absconder since 2021. Ms. Malfino?
Judge, I think the consideration that he was given was with the cap of 4 years. I completely understand if based on the original PSI and his history and his attitude, the court does not think that that is an appropriate amount. But I would obviously recommend revocation, whatever amount you think is appropriate if we need to revisit that issue.
What happened with the Sabine County DWI back in 2017 at the same time as this one?
They dropped it.
Okay, at this time I'm going to find that you entered your pleas of true to counts 1 through 6. Find those counts true. Ms. Malfino is exactly right. You're lucky that you made a plea agreement for 4 years, because I'm not really sure that not showing up since 2021 and just saying I want to take my time and be done with it is the kind of attitude that I appreciate. But I'm going to find sufficient evidence at this time to revoke your probation, and at this time revoke your probation, reassess your punishment to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you have waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Good morning. Are you Jeremiah Johnson?
Yes, ma'am.
And Mr. Johnson was previously here in cause number 250330, entered a plea of guilty to